Alrighty, so this is Diesel We the People News. Okay, this is more of a learning video than anything else. Okay, so let's figure out some Latin words that they may use on your paperwork or in court. Okie. And let's see here. How am I going to do this? There we go. All right. This, first of all, this is Diesel We the People News, right? All right. This video is without prejudice and or without recourse. I'm going to go ahead and stand on the UCC 1-308, all rights reserved. Okay, I'm not an attorney, so I'm not giving legal advice. Anything I say or do is going to be opinion only. Why? Because I'm not an attorney. And I never just look straight forward. I always try to look around me to be able to protect myself by any means necessary. Even learning some words. Alright? So let's proceed forward. What do you think?
Alright, so number one, ab initio. Ab initio, what does that mean? Means...
Alright. It's a AB. Then slash in there. INITIO. So when you look it up.
From the beginning, that means it's often something you'll see in a legal opinion that says something was void, ab initio, void. And that really means from the inception, So, for example, you might have a void contract due to fraud. So you may see a legal opinion that says this is void ab initio. Okay, that's a nice one to know. All right, actus reus. What does that mean? Sounds like a Greek movie.
All right, that word's ACTUS, and then REUS.
Movie of some sort. This is a criminal law term, and it means guilty act. And it usually goes along with the guilty mind, which is the mens rea, to prove criminal liability. So when you're taking criminal law, you'll usually find most statutes require some sort of criminal intent. Some don't. There are strict liability offenses, but the actus reus is the guilty act. That's really easy to understand, and the mens rea is the guilty mind. You put those two together, you have potential criminal liability. Okay. Next one, ad hominem. This is something.
Alright, AD. Then HOMINEM.
Where you may be in court and you make a great, brilliant, dazzling argument, and the opposing attorney says, oh, you know, Mr. Vonderen's the worst attorney that ever lived and existed and walked the planet. And so what they're doing is they're not addressing my argument, they're attacking a person or their character. That's what we call an ad hominem attack, okay? Next one, affidavit. What's that?
Well, just to be argument's sake, AFFIDAVIT.
Affidavit means sworn facts. These are sworn facts made by a person under oath, which is under penalty of perjury. Okay, so this is admissible evidence in court. Now, usually an affidavit, it's very similar to what we would call a declaration, and that's where you're telling the court that you have personal knowledge of certain facts, and that if called to testify, you could and would testify as follows, and then you put down the facts that you're willing to testify. So that's an affidavit that becomes, because it's under oath, something that can be deemed admissible evidence in court, and people use it with their motions and things like that. Now, versus a jurat. Now, affidavit versus a jurat. Every now and then you might hear the term come up, jurat, I need a jurat. Well, that's a sworn statement in front of a notary. So that a jurat would be where you are swearing, taking some sort of oath in front of a notary, and the notary is basically noting that with the notary stamp. That is affidavit, another Latin term that you need to know. All right, here's another one, amicus curiae. That one sounds fancy. I like the sounds of that.
AMICUS CURIAE.
What is that? Refers to someone writing, oh, I called it, this is what it usually refers to, someone writing a friend of the court brief, even though they are not a party to the action. So say there's a big copyright case going on in DC circuit courts or whatever. I can write a friend of the court brief, or a lot of times you'll see this in big Supreme Court cases, for example. Somebody will write an amicus curiae brief. Okay, so it's friend of the court. The goal is to influence the decision maker and point out things that the court may not be aware of. Take, for example, there's like a lot of different issues. Maybe there's something on, there's a big case on music piracy, let's say. There's a lot of different angles to the music business. A good amicus curiae brief can help point the judge out, point some things out that perhaps the judge is not aware of. So that's the purpose of that. Also could be someone being called, like an expert, someone being called to give special evidence or special testimony before a tribunal. That's a good one. Amicus curiae, put that in your toolbox. All right, bona fide. I think we probably know what that means, but just in case.
Yep, just in case. BONAFIDE.
It's good faith, bona fide, good faith. Like you may hear this we heard this a lot in foreclosures when somebody was a bona fide purchaser for value at a foreclosure auction. The people that are bona fide purchasers get a lot of protection under the eyes of the law because their offers were made in good faith. It's bona fide. Okay, so there's another one for you. Moving on, de minimis. Okay, de minimis.
All right. DE. And then MINIMIS.
Is minimal. It means basically minimal. And the old maxim in the law is the law will not concern itself with trivial matters. The law will not concern itself with trivial matters. So there you may be involved in a case where it's something so minor that you're going like, why on earth am I being sued here? I mean, I get it, but I mean, they're talking about a matchstick or something. We're talking about something minor here, very minor. This may be something you want to bring up. De minimis is another great Latin term. De novo, this refers to anew.
De novo, pretty common use. DENOVO.
It stands for anew, and this is where you may have a trial de novo, where a court can order a new trial, basically starting from scratch. For example, where a verdict could not be reached in a trial. So that's a de novo. Sometimes you may hear this will be a de novo review, and that's what they're referring to. So another great Latin term to know, de novo. Dictum, I love this one, and this is
DICTUM.
Important because in law we have legal precedent and then we have things that are dictum. So you may have a case that you're reading and you go, ooh, there's some great language in there for me to use in my briefs. But the other party may say, well, Judge, yeah, that was dictum. It was not central to the holding in the case. It was just a judge sort of talking about something that was not central to the key issue in the case. So that is what we refer to as dictum. Another way to look at that is it's a little off point. If what we say, if a case is exactly the same as a prior case and the judge is ruling on that and issues a holding, that holding is the rule of law. Dictum is, as I say, you can cite it, but a good opponent will point out that this is just dictum, Your Honor. That's dictum.
Just my opinion, because I'm not an attorney. But if you challenge jurisdiction and they keep going without defying the jurisdiction you're under, there you go.
All right, forum non-conveniens, another fancy term here.
FORUM, and then NON, and then CONVENIES, NS.
This really means there is a better forum or a better court for an issue to be decided. So this, in a sense, relates to the jurisdiction of a court. Is it the best forum? Is it the best venue for a case to be heard? If not, a court or a judge may refer the case out to be heard in a better, more convenient forum. Okay, moving on. Here is gravamen. I love this one. This is
That does sound good. Gravamen. Gravamen. Love how that twists the tongue a little bit.
I always think of, like, I don't know, I look at it and I think of caveman, but gravamen. And this may be, this really comes up more in opinions when you're reading case law. The judge may talk about the gravamen of the complaint is this, or the gravamen of the complaint is trademark infringement. So gravamen refers to what is the key point, what is the main point or purpose of the complaint, or it could be some other pleading or other document. What's the gravamen? What do you really, what's the key here? Okay, that's a great term, by the way. So it's another legal term. Let's move on. Habeas corpus. Habeas corpus.
Just for some that don't know, Habeas and Corpus.
This is something you might see on TV, and you may see in a criminal courtroom. But basically, this refers to a writ that is filed by a prisoner to see if they are legally being held or detained, and essentially means you have the body. And this, what they're talking to in regards to habeas corpus, is they're saying there could be an order that the detaining party, that could be the state government, the prosecutor's office, to have to bring the living body of the prisoner before the court, so the court can decide whether or not this person is being legally detained. And you'll see, if you look up federal court cases, there's a lot of writs of habeas corpus being filed. It's a bit, I would say it's a business all into itself. If you really are dead set on doing criminal law, a writ of habeas corpus, there's a lot of those that are being filed. All right, move.
And I would go so much further. Again, I'm not an attorney, it's just my opinion. But even if you go to jail without being able to see a magistrate before getting booked in, well, there was no due process involved in that. They'll argue about it, but there was no due process.
On. In camera, what does this mean? No, it's not a photographer's convention.
Easily said, right? INCAMERA.
This refers to having well, I call it a secret meeting, but a private meeting in the judge's chambers. Okay, this is the opposite of doing something in open court. So you may go back and, to me, this is one of the funnest things that judges do, and I wish more judges did it. A lot of federal judges like to do it, and to me, it's a lot of fun. But you go back into a judge's chambers, and no, you don't pour yourself a cocktail and talk about golf. You get back in there, and they may have some clerks in there, and you talk about the legal issues in sort of an informal setting. And this is what's known as, if the judge orders it, it would be ordered in camera. Okay, there's sometimes the judge just says, hey, everybody back in my chambers, but this is actually in camera. And this is something where for some reason you don't want something to be heard in open court. It could be you have trade secrets, could be attorney-client privileged conversations where you're claiming a privilege on something. So if the judge orders you in camera, an in-camera hearing, in camera in the chambers, boom, that's what we're talking about, okay? Next Latin term you need to know, in personam.
That's fairly common. INPERSONAM.
Now you can sort of see the word person, that kind of tips you off a little bit, but in personam, this refers to jurisdiction of a court, to be able to hear a case and to render a decision over a party. There must be in personam jurisdiction. This is what, if you're in law school, this is what we call the minimum contacts. Do you have minimum contacts enough with a certain state or jurisdiction that you can expect to be hauled into court and forced to answer the claims, and gives the judge the power, the jurisdiction to render a decision. So, for example, you could be sued in the Central District of California. You may have a little house up in Kennebunkport, Maine, and you may be saying, why am I being sued in California? I've never been there. I don't have a website. I've never visited there. I'm not, seeking the protection of the forum or the benefits of the state. There's no in personam jurisdiction. So that's another great Latin term. It comes up all the time. A court needs to have the in personam jurisdiction and subject matter jurisdiction. Okay? That's a great one. Here's lis pendens. This one,
L-I-S, then P-E-N-D-E-N-S.
really confuses a lot of people. I've had a lot of pro per plaintiffs and other people call our office. This really comes up in real estate law, but it's a real estate term, which means it's Latin for litigation is pending. Now, some people will call my office and say, I want to file a lis pendens. I want to file a lis pendens. Well, I say, okay, have you filed a lawsuit? Well, no, I haven't. I want to file a lis pendens. I want to cloud the title. And you say, well, lis pendens means litigation is pending. You have to file a lawsuit first. So this is typically just a document that gets filed with your county recorder's office. It clouds the title. So, and I tell people, it doesn't cloud, it clouds the title. It doesn't mean that somebody wouldn't buy or sell the property. It just means there's a cloud, and it means you could have a hard time getting title insurance. So that's lis pendens, another fantastic Latin word you need to know. All right, moving on here. I hope you're taking good notes here. If you get this stuff, you're going straight to the top. Locus delicti, this is a criminal law term.
Locus delicti, L-O-C-U-S, then D-E-L-E-C-T-I.
Term refers to the scene of the crime. Locus delicti. That's a fun one. Just rolls off your tongue. Next one, malum in se versus malum prohibitum. Oh.
That's a mouthful, right? M-A-L-U-M-I-N, then S-E, versus M-A-L-U-M-P-R-O-H-I-B-I-T-U-M. This is just in case people want to look up these words.
Okay, these again are criminal law terms. Malum in se means it's inherently evil or it's inherently wrong. So it's like murder. Murder is malum in se. You don't really need a statute to tell you that. You should know that. Rape, mayhem, those kinds of things. They're inherently evil.
And we also call that positive law.
Are referred to as malum in se. Malum prohibitum are really just something that is wrong, and I put here due to the legislature prohibiting it. You're passing laws saying, well, it's against the law to jaywalk. Say, well, I know that's bad, but is it really that bad? Is it inherently evil? So there's your difference in a nutshell. Malum in se versus malum prohibitum. That would be a fancy one to throw on your bar exam. I would think that your examiner would know that you're really working overtime here, watching Attorney Steve videos. All right.
And then I would go with the other one as a non-positive law. Alrighty. We're going to go on to the second video of this, so don't extend too long. Alright, this will be the People News.